Good evening, everyone. On behalf of the Committee on Commercial Laws, Economic Advisory, and NPO Cooperative of I, Nidhi Bang, moderator of this webinar, welcomes you all to day two of the Knowledge Express Week. This week, long initiative aims to update and empower chartered accountants across India, covering key topics like succession planning, anti-money laundering, FEMA, RERA, presented by leading experts. Today's session is dedicated to ADR, institutional arbitration, for which we have Inba Vijayan sir and Piyush Chajit sir with us. Sir, we welcome you both. ADR is an increasingly important mechanism for resolving commercial disputes efficiently and professionally. Understanding this processes enables chartered accountants to better guide clients and organizations in navigating legal and financial complexities. This committee continuously organizes high impact webinars and sessions to equip members with practical insights and the latest regulatory updates, fostering excellence and innovation within the ICI community. We are grateful for your participation and encourage all attendees to actively engage, making the most of this collaborative learning platform. Before moving ahead, I request Piyush Chajit sir to kindly deliver the opening remarks, and it is my absolute honor to introduce him. He is a CA with 25 years of professional experience and serves as a senior partner at a firm in Mumbai. And with providing a strong foundation in finance and taxation, he specializes in tax litigations and advisory. He has been a Central Council member of the ICI for two consecutive terms and has served on all three standing committees. He is currently the chairman of the Direct Tax Committee and vice chairman of the Export Advisory Committee of ICI and has represented India internationally as a member of the various working committees. Now, sir, please kindly deliver the opening remarks. Over to you, sir.
Thank you very much, CA Nidhi Bang, who's from Indo. Thank you for your wonderful introduction. A very learned speaker for the day, Advocate V. Inba Vijayanji. Thank you very much for joining it on behalf of our committee, which we call actually a clean and NPO. Thank you for joining us on the second day, and wherein we will be discussing a very important topic, I know, of alternate dispute resolution, basically institutional arbitration. And just for the very good evening to all the members who have joined today. And for the benefit of the members and the speaker today is our second day of this Knowledge Express Week, wherein every day from 5 p.m. to 7 p.m. the seminars will be held. And today is the second day. It will continue up to 5th. And we'll be also discussing the day after, tomorrow, in fact, rather combating money laundering. Then we have some session on FEMA and FCRA also, and RERA also. So I'm sure all the participants will be staying tuned to this particular channel and be looking into it. My compliments to the chairman of the committee, C. A. Chajit, and vice chairman, C. Pramod Jain, for organizing such a wonderful week. And I always speak to chairman also that you always have a series of weeks where you have a global weeks, you have a knowledge weeks. And I think so. It's a very wonderful exercise for the benefit of the members, which has been done. Coming to the topic, obviously we have an expert today who would be building within the detail. But yes, it's a very important today. Institutional arbitration. It is not only the institute which is talking about this, but various associations, chambers of commerce, I would say FICCI, Ashokem, everybody has done their setup wherein arbitration could be an alternative method rather than doing a legal fight. And as a chartered accountant, it was imperative for Institute of Chartered Accountants of India also to take a lead into it. And in fact, under the leadership of Abhay Tajad, we have already now incorporated Section 8 company also, which will deal with alternative dispute resolutions. As a chartered accountant, we all know we have a latest insights. We are supposed to be updated on key domains of law, economic policies, and cooperative sector governance. And therefore, since we are updated on this area, obviously the arbitration could be one of the very great area where the professionals can provide their services, can be helpful to the business houses, and arriving at I would say arriving at a resolution which would save them from a long legal battles. That's I believe. Of course, as I said, today's theme is very much institutional arbitration, which is extremely relevant in the context of modern business and professional practice. Today, the commercial disputes are increasingly complex and time bound, I know. But if you see the pendency in the legal quotes, which we actually hear from the newspapers, I'm sure the speaker would be also enlightening that a huge number of cases are pending. And in any high court of any particular state, I would say that if you want your matters to be resolved, it may take a decade or two for that matter. And therefore, institutional arbitration has emerged as a preferred mode of a dispute resolution, I'm sure. It has a structured procedures, neutrality, and approach rooted in global best practices make it critical mechanism for delivering justice efficiently in commercial matters. In fact, from ICI side also, I think so. We have a certificate courses and a continuous knowledge initiatives are taking in this field also, so that chartered accountants are upskilled in the area. In fact, a lot of our chartered accountant members are also recognized as arbitrators. They also serve as expert witnesses and advisors in dispute resolution forums. So you may not be an arbitrator, but a lot of chartered accountants are been even today playing a role whereby they are presenting the facts before the arbitrator. So this could be a one step ahead, wherein they can also be think of being a mediator or an arbitrator, because there is definitely a trust impact which has been reposed by the various people on this profession. So I'm sure this sessions would be quite insightful. My request to all the members who have joined today evening, I'm sure please be tuned to this for next 2 hours. It would be a very insightful one. And this institutional arbitration, who have not yet started, may provide a new professional avenues, not just as an arbitrators, as I said earlier, but maybe as a thought leaders, the way you think about it, the way you look at the disputes and you are able to do justice to it. It may not be as an arbitrator, but maybe as a different areas of the professions also. So I urge you once again to please engage yourself in today's session. If you have any questions, you can raise those questions. I'm sure Nidhi would be looking into that and would be also posing it before the speaker. And you can also share your experiences by that. So I again extend my gratitude to the expert today's the advocate. Che, I'm just sorry, advocate Inba Vijayan, I would say. Thank you for once again for joining us, and it would be a great insightful session. Thank you very much. All the best to you.
Thank you
Over
so
to you,
much,
Nidhi.
sir,
Yeah.
for sharing such valuable words with us. Now it is time to introduce our eminent speaker, Inba Vijayan sir, and it is my absolute honor to introduce him. Sir is a full time arbitrator and ADR practitioner with over 2 decades of experience since 2001. He has presided over 450 plus domestic and 19 international arbitrations and is authorized by leading global ADR institutions. He is actively promotes ADR through lectures, training, and institutional development. He is admitted to the Indian Bar in 1997. He has held foreign lawyer registrations in Singapore and the UK, and currently as audience rights before the AIFC court, Kazakhstan. He teaches ADR and international arbitration at major law schools, including IMU and Manipal Law School. He is founder of the Global South ADR Alliance. He also serves on the governing council of the Indian Council of Arbitration and has represented India in several international delegations. Now I request Sir to kindly take over the session.
Thank you, CA Nidhi, for giving the introduction about the future career for not only for lawyers, but as rightly pointed out by the Central Council member, CA Piyush, it is going to be a great opportunity for each and every one, whether they are chartered accountant or a lawyer or any other professional. We do have an opportunity to be an expert, be a consultant, be a counsel, and also be an arbitrator or a mediator. This is the initial word, what I wanted to say. And rightly, uh, this particular committee, under the leadership of Mr. Abe, has taken this initiative of knowledge series and taken this topic on the second day. Very interesting. The task given to me is to highlight about the concept of institutional arbitration. This is the right time. Why? Because institutional arbitration, as such, in the perspective of CA Institute, a month back, CA Institute launched its own arbitration institution. Interestingly, the institute is called IIAC, and this institute is going to be a real-time example for the larger arbitrations which are going to be dealt by chartered accountants. Having said that, as a knowledge series, it is my responsibility to come out with some research or a structured presentation, what I have done, so that it might be a clear and candid understanding of what a basic institution, arbitration, and ad hoc arbitration, and a comparative analysis of it. Generally speaking, even though many would be aware about the term arbitration, we have to first of all, for the better understanding for the larger audience, an arbitration is a private process which is to resolve disputes outside the court. And in India, by way of several legislations, whether it is a civil procedure code, that is a 1908 grand old legislation, or the present day 1996 Arbitration Conciliation Act, arbitration is recognized. And this recognition literally had an origin from the United Nations Commission for International Trade Law, that is the ancestral model law for international commercial arbitration 1985. When you look on the term arbitration, what the law says, the first provision under the definition in the Arbitration Conciliation Act of 1996 very specifically says that an arbitration means an arbitration whether or not administered by a permanent arbitral institution. This is the meaning for the term arbitration given under the Indian arbitration law. When I literally look into, or when I started getting into arbitration in the early 2000, I was really confused why it is very simply mentioned whether or not administered by a permanent arbitration body or an institution. And later part of the law doesn't even speaks about what is institutional arbitration or even what are the types of arbitration available in our country. But the takeaway at the time of understanding the term arbitration, it also goes with the understanding of a permanent arbitral body or an institution. To catch up, what is institutional arbitration? Initially, I ventured into understanding what might be the key features of arbitration, and the answer what was evolved was consensus, that is consensus ad idem, neutrality, binding, as well as an ADR mechanism. An arbitration is a process which is considered to be an alternative dispute resolution mechanism, that is ADR. Many of us would know ADR to be the alternative dispute resolution, and now it has gone to the level of appropriate dispute resolution, passing through accepted dispute resolution, authorized dispute resolution, and authenticated. There are 5 probabilities of ADR to be understood now. The traditional one was alternative dispute resolution. The growth was accepted dispute resolution, authenticated dispute resolution, authorized dispute resolution, and now the present day understanding of ADR is appropriate dispute resolution. Whatever might be, when you're trying to just understand or accept or implement this particular mechanism, this mechanism that is arbitration comes within ADR. That was the first thing I understood. Second, how to reach this mechanism and the basic feature, what can be taken up in arbitration is that consensus ad idem. This mechanism is out of acceptance, voluntary acceptance of the disputing parties. Whether it is two or more than two, the consent by both the parties or more than two parties obviously makes that process effective. That becomes the next future, interesting feature. It is also neutral. Why? Because the process which is not handled by the courts, the process which is ADR, the process is by way of mutual consent, eventually needs to have a well-balanced neutrality. And finally, this process gives a binding outcome, which might be considered as final and binding. Anyway, it is a binding outcome. Across the globe, in addition to these four key elements, we also need to understand the enforceability and impartiality of this dispute resolution process. A process which is happening outside the courts with the consent of the parties, guided by neutrals, giving an outcome which is binding, is also enforceable. No doubt, this process has to be impartial. These are some key elements of this process arbitration. And in India, all these are the basic principles which underline the arbitration process. Okay. What are the essentials of arbitration? We need to have an agreement or a clause. We need to have consent through this clauses or agreement. We need to have a neutral platform, and also it has to have the enforceability. All these forms part of the essential element or ingredients of an arbitration. An arbitration agreement forms the backbone of the proceedings. Technically, it is a foundation of the proceedings. Without the backbone, a human being can't be differentiated from a primate. This arbitration agreement is actually facilitating the arbitration as a whole. The consent, which becomes the next essentiality, should be voluntary and also ensure the fairness and party autonomy. Party autonomy becomes the brain of the arbitration process. Further, the neutrality of the tribunal and the seat, which guarantees the impartiality, becomes the limbs, hands, and legs of the arbitral process. We can stretch to that level, but it has to be limited to neutrality, and it also guarantees the impartiality. We have to just properly walk and properly do our activities with our hands. And finally, the enforceability under the law gives the finality of the award, which makes that process efficient and acceptable by all, even the courts, when it comes to enforcement. This enforcement is obviously the eyes of the arbitration proceedings. A proper human being having a backbone, having brain, having limbs, and also having eyes, with the key element of the dispute being the heart and other organs, makes us the essentiality of this particular process, which is also there in the courts, but with certain limitations, which is not there in the arbitral process. Another thing, what has to be addressed or understood initially is that who can arbitrate? Who are the parties? Who are the stakeholders in the arbitration process? A party being one of the stakeholder in an arbitration might be an individual, might be an entity, whether it is a LLP, LLC, a partnership firm, a company, a private company, a public company, a listed company, a consortium, and it can also be a state, a sovereign state. There is no restriction for parties to be identified in the manner in an arbitration proceedings. No doubt, individuals with legal capacity should be parties, companies and corporations, sovereign states and public sector entities, partnerships and associations, any legal person capable under the substantive law of that particular place where the arbitration is happening. It is also similar to how we are going to deal in the courts. Okay. Who can be in party? Fine. What disputes can be arbitrated? We do have certain limitations. It is not that all disputes can be taken to arbitration. There are some limitations. The general principle is that any civil dispute with a commercial element, a commercial dispute, as well as contractual disputes are arbitrable. Under non-arbitrable criminal issues, matrimonial issues, insolvency issues, guardianship cases cannot be arbitrated. But to bifurcate which one is arbitrable and which one is non-arbitrable, we don't have proper provisions in the law. The only available in the Arbitration Conciliation Act is Section 2, subsection 3, which says that Part 1 of the Arbitration Conciliation Act can deal with the dispute, not all disputes, and they have to avoid the disputes which are exclusively dealt with special statutes. If there are some laws for criminal, we do have the criminal procedure codes and the other criminal laws. For matrimonial issues, we have the Family Courts Act. For insolvency, we have the IBC. For guardianship issues, we do have the personal laws. If there is some law in our country which is both substantive and procedural, that is special statute, which gives opportunity of disputes to be taken to a forum and also gives a procedure like creating a tribunal. Good example, consumer disputes. Consumer disputes is non-arbitrable. Why? Because we do have a Consumer Protection Act. The Consumer Protection Act 1986, with its recent amendment of 2019, facilitates creation of consumer redressal forums. We can take our dispute only to the consumer redressal forums, whether at the district level or state level or the national level. It is not that we can take it to arbitration. We cannot do it. For insolvency, we do have under the IBC, the National Company Law Tribunals and other forums. For tax disputes, we can take it only to the tribunals constituted under the various direct and indirect taxation legislations. Majorly, to identify a disputes to be non-arbitrable, we have to analyze whether the right which we are trying to enforce in that particular dispute resolution process is against the entire world. That is technically right in rem. When we are going to exercise our right against the entire world, that is right in rem, then those disputes cannot be arbitrated. But when we are going to establish our right in personam, that is our personal right, then that dispute can be arbitrated. Two principles to bifurcate arbitrability and non-arbitrability. One is if there are special statute which is both substantive and procedural, and another one is right in rem and right in person. Anyway, when it comes to arbitrability, it is all about the public policy and statutory interest. And the best case in 2011, that is Booz Allen versus SBI Home Finance, is a very significant judgment of the Apex Code, which gives a lot of guidance how to arbitrate, which dispute is non-arbitrable. All these bifurcations have been categorically listed in this particular judgment of the Apex Code. Generally, the term used for arbitrability is that a dispute with private rights are arbitrable. But as a professional getting involved as a stakeholder or as a career prospect, these two things, right in rem, right in personam, as well as disputes which are all dealt by special statutes, which is substantive and procedural. Now come to the categories of arbitration. A soft input about the concept of ad hoc and institutional is very simple. Ad hoc arbitration is nothing but opting for a choice-based marriage, and an institutional arbitration is an arranged marriage. I'll try to explain how it is choice-based and arranged. Ad hoc arbitration, whether it's the meaning, features, or limitation, the basic understanding is that if it is ad hoc, obviously it is not an institutional administered arbitration. That is, no institution is administering or involving in that particular arbitration process. As earlier mentioned, arbitration is a process happening outside the court, but still parties might get some assistance or some institutions would be administering. And if there is no such administration done by institution, just depending upon the legislation, that is the Arbitration Conciliation Act of 1996, and if a parties are involving in an arbitration, then it is an ad hoc arbitration. There is no institutional administration happening. Here, the parties are managing the procedure as well as the appointment. That is, the procedures are laid down, mutually agreed by the parties. And when it comes to appointment of an arbitrator, whether it's sole arbitrator or three arbitrators, the sole arbitrator and the third arbitrator would be on mutual consent of the parties, and they themselves appoint. The party autonomy is very clear in ad hoc arbitration. Parties are choosing the procedure, parties are also choosing and appointing the arbitral tribunal. The law is very clear. When you're trying to address arbitral tribunal, it is identifying a sole arbitrator or a panel of arbitrators. Technically, it has to be 1, 3, 5. It should not be even numbers. But still, in an ad hoc arbitration, a major feature is that parties appoint the arbitrator. Ad hoc arbitrations offers flexibility. Why? Because in ad hoc arbitration, the law clearly mandates that the arbitral tribunal is not bound by the procedures laid down under the Civil Procedure Code 1908, as well as the Indian Evidence Act 1872, the present PSA 2023. It is also a cost-saving process wherein there is a reasonable cost incurred in an ad hoc arbitration. There are four heads of cost normally in arbitration. One, the fees and expenses of the arbitral tribunal, including witnesses. Two, legal fees and expenses. Three, if an institution is engaged, the administrative fee of the institution. Fourth, miscellaneous. When you are opting for ad hoc, arbitrators, that is fees and expenses of arbitrators, the fourth schedule in the Arbitration Conciliation Act guides gives an upper cap for domestic arbitration, not for international, but for domestic. In that way, it is cost effective. The legal fees and expenses depend upon whether it's ad hoc or institutional or even a court process. Obviously, the lawyer's fees and expenses would be incurred. Third one, if we are engaging institution, then we have to pay additional. If you are ad hoc, that cost is not included. In that way, cost is saved in ad hoc arbitration. That doesn't mean that ad hoc arbitration is best. My presentation would be saying that institutional arbitration is the future. The risk of procedural delays and inefficiency might be there in an ad hoc arbitration. But still, in India, the Arbitration Conciliation Act has undergone 3 amendments, and the first amendment in 2015 gives a specific time frame for arbitration. In that way, reasonably, this procedural delay has been addressed in ad hoc arbitration. And the final one, it lacks sometimes standardization and supervision. There is no court to supervise. The court has no authority to intervene the arbitration process. It is all party driven, and in that way, there is no external authority, a third party supervising, so that it might lack standards. It's not that always parties might be efficient, but still there is no third party which is supervising the way how it has to be conducted, even though under the Arbitration Conciliation Act of 1996. Coming to institutional arbitration, these are some basic definitions or concept for us to keep in mind, looking into the other part of my presentation based on these slides. It is administered by recognized arbitral institution. And it can also be mentioned that it is administered by arbitral institution. Recognition is not so mandatory as of the present situation. But still, it is administered by a third person. That third person here is an arbitral institution. It is likely to follow fixed procedural rules, and there will be an oversight by that particular institution on that arbitral proceedings. It no doubt provides administrative and technical support. Here, there is high possibility of ensurance of consistency and expert handling that particular dispute is evident. As a procedure, it promotes timely and impartial outcome. Getting to the third point in the slide is very important. Institutional arbitration provides administrative and technical support. How come? Where is the authority? It is an administrative support or a technical support. From where to get it? Here, fortunately, the Indian Arbitration Conciliation Act 1996 under Section 6 clearly gives a mandate administrative assistance. The arbitral tribunal with the consent of the parties, can very well engage an institution to get administrative assistance from an institution or an individual to effectively conduct the arbitration. It is somewhat like a hybrid, ad hoc combination of institution. But still, the law itself moots parties to go to institutional arbitration, at least to begin with administrative assistance. In that way, institutional arbitration is evolving as a future arbitration category. What might be the initial debate or competition or difference between ad hoc and institutional? In ad hoc, it is all party controlled. It might be flexible, but still it is unstructured. Institutional, it is totally managed under formal rules as well as well established systems. Institution minimize delay through oversight. Coming to ad hoc might suit small value disputes. Institution might suit complex and high value disputes. I'll try to explain why all these are being listed out. Before going into the depth of the component institutional arbitration, we need to understand the evolution in the same law beyond the principal act provisions. Before 2019, there was a second amendment in the Arbitration Concession Act. There were no statutory recognition of institutions to be engaged, or it's a recognition of institutional arbitration directly. Section 6 was there before this, but still it was not straight away giving a recognition for institutions. Just assistance can be taken from institutions. It was in 2019 the amendment introduced arbitral institutions concept. The word arbitral institution, not arbitration institution, the word arbitral institution was introduced. And where it was introduced, section 11, subsection 3, capital A, it was included that court may designate graded institutions, particularly graded arbitral institutions. And this grading would be done by Arbitral Council of India, which was included in section 43, capital A of the same amendment 2019. The post 2019 arbitration regime is all about strengthening India's institutional framework. India, from 2016, when the Niti Ayog started recommending institutionalization of arbitration, the year 2019, with the changes, amendments in the Arbitration Concession Act, started strengthening its institutional framework in arbitration. What actually the term arbitral institution is defined? The research clearly mentions that it is nothing but an organization or an institution that is likely to administer arbitration. That's all. They are not use the word facilitation. They are not use the word conduct. They are using the word just administering an arbitration. It's all getting back to the traditional definition of the term. Arbitration means an arbitration, whether or not administered by a permanent arbitral institution. It sets out procedural timelines and oversee complaints. Very important. Due complaints have to be taken up, and there is a very limited scope for violating or breaching these procedural timelines. If there is likely to be violation, it would be done by paying a huge cost by the party who is trying to delay the procedure. Even if it is an arbitrator, that he has to compromise on his cost or the fees, what he is entitled for. Interestingly, when you are dealing with arbitral institution, the institution by default, the parties couldn't agree within a reasonable shorter time. The institution would appoint arbitrators as well as fix fees based on the schedule of fees and cost, what they are following based on their customized rules. It also ensures reasonable transparency and fairness. In arbitration, the proceeding has to be confidential, but still there should be some transparency when institutions are involved. The institution secretariat would be aware about the entire proceedings, even though they are third party to the arbitral proceeding. But generally speaking, there are many institutions, very prominent institutions across the globe, like certain are being listed here. ICC, it is nothing but the International Chamber of Commerce. LCIA, the London Court of International Arbitration. These two are quite old institutions, more than 100 years have gone since its inceptions or operation. Then we have the Singapore International Arbitration Center, which is a very prominent, active arbitration institution at present globally. We do have the Mumbai Center for International Arbitration, a new venture in India, similar to the Indian Council of Arbitration, which is a grand old 1965 institution. We also have institutions like Hong Kong International Arbitration Center in the Hong Kong Special Administrative Region of the People's Republic of China. There are many such arbitral institutions across the globe and in India, wherein those organizations administer arbitration, set out procedural timelines, oversee compliance, appoint arbitrators as well as fix a fee structure, and make insurance or assurance that there is reasonable transparency and fairness so that that arbitration can effectively be concluded. Now, we can try to just analyze and understand what other things we have to look upon when it comes to institutional arbitration and the role of rules, particularly on appointment process. The institutional arbitration predominantly have list system. Anyway, as a flow of this presentation, if you take an example of ICC, that's the International Chamber of Commerce, in Article 12 of the institutional rules of ICC, there is ICC arbitration rules. It deals about how appointment has to be done. Whenever required, as a default provision, institutions appoint arbitrators. Here, there is no role of court. Similar, when you're dealing with the Indian Arbitration Conciliation Act of 1996, there is a provision, section 11, which says that if the parties couldn't agree of the appointment of the sole arbitrator, the third arbitrator, obviously, one of the party, after 30 days, can approach the High Court for domestic and Supreme Court for international, for those authority to appoint arbitrator. But in institutional rules, the courts are avoided when it comes to appointment of an arbitrator. No doubt, the institution ensures neutrality and professionalism and promotes timely constitution of the tribunals. That's very important. The courts under 11 after the 2015 amendment give certain opportunities like a reasonable time, or the court shall make an endeavor to appoint arbitrators within a reasonable time of 60 days, 90 days. Likewise, the amended provisions are there. But in institution, there is very, very limited time given for the institution to appoint. In that way, the court intervention is minimized as well as delays are avoided. The arbitrator's quality would ensure neutrality and professionalism if they have been appointed by the institution. And how these institutions appoint. When you look on these arbitration rules of the institution, some institutions have panel of arbitrators. Some institutions have list of arbitrators. Some institution has pool of arbitrators. Some institution has database of arbitrators. Some institution has a prospective list of arbitrators. This is a list system which is commonly used in developed jurisdictions, including developing like India. When you take the example of Indian Council of Arbitration in India, they do have panel of arbitrators which might runs more than 2,500 arbitrators are listed in their panel. And it is not a single panel, it is a panel of arbitrators having engineers, panel of arbitrators, retired judges, panel of arbitrators, chartered accountant, panel of arbitrators, lawyers, panel of arbitrators, engineers, panel of arbitrators, cost accountant, panel of arbitrators, so and so, any professional. So much of panels would be maintained by that particular body, and in that context, those bodies would pick up names from that panel and appoint or see the consent of the parties by giving 5 names. Assuming that the 5 names are included, 5 names would be given to both the parties and they would be asked to prioritize that list. A, B, C, D, the names are given, and across A, whether it's 1 or across B, it is 1, that priority list has to be prepared by the respective parties. And if there is a balance, assuming that the list 3, it is A, and in the list 3 of the other party also is A, then A would be appointed. The list system is effectively working in most of the institution. Institution like ICC, Article 12 is something unique. Assuming that there are 2 parties coming from different countries, one coming from India, another coming from Germany, and an ICC arbitration happening in Paris. Most of these international arbitrations, the number of arbitrators would be 3. The Indian party would appoint an Indian arbitrator or an arbitrator with Indian nationality. The German party would appoint a German national as an arbitrator with a specialized knowledge on that subject dispute. Now, the arbitration is happening in Paris. Obviously, an arbitrator in Paris would be chosen by the institution. And that Paris station arbitrator would also be chosen from the recommendations given by the National Committee of ICC in France. ICC has a lot of national committee. In India also we have, that is called ICC India, that is ICC National Committee in India, or the Indian National Committee of ICC. Likewise, more than 70 odd countries have its own committees, national committees of ICC. And depending upon the seat, the person from that particular region or the country would be recommended for appointment. Ultimately, the ICC court, International Court of Arbitration, would appoint the arbitrator. And we do have institutions like Singapore International Arbitration Center, the Asian Institute of International Arbitration, or the Asian International Arbitration Center. These institutions, in addition to, or when it comes to appointment of an arbitrator, the secretariat would be bifurcated as case management as well as the court. The case management would have a team of CEO, registrars, case counsels, as well as the judicial clerk of that particular institution. Alternatively, when it comes to court of arbitrations in those institutions, they will be comprising of not the secretariat, just the CEO might be there as a part, one of the person, and all other would be practitioners who are no way connected to the institution. They might be coming from different national, and that court ultimately decide who to be appointed based on the majority of its court members. The institution appoints arbitrators whenever needed, but still the appointment process under institutional arbitration has been clearly, crystal clear, highlighted in most of the arbitration institutions which you have earlier seen. There is no discrepancy or defective provisions in any of these arbitration rules of institutions. The default role of institutions in appointing arbitrators, particularly as a default mechanism, whenever the parties fail to agree, then the institution takes up the role of appointing authority and appoint. The institution prevents stalemates and procedural breakdown. The institution might be considered as a default appointing authority and makes the progress in the arbitration process by appointing the arbitrator at the earliest possible time. Here, even though they are just rushing for the appointment, this appointment or selection process is purely based on expertise and independence of the arbitrator or the arbitral tribunal. Overall, as the institutions are taking up the role for appointment as a default mechanism, it also assures or supports the aspect of impartiality and efficient adjudication. What might be some challenges in appointment of arbitrators when it comes to institutional arbitration? Assuming that the institution provides some 5 names for both parties to respond with their priority, most of the cases the parties would disagree. This habit of disagreement or practice of disagreement eventually causes delay. Further, allegations of partiality in selection is a serious challenge. In India, very common thing, unilateral appointment. One party taking the initiative to appoint the arbitrator in all the cases. There might be probabilities of allegations of partiality. or pertaining to corporations or communications. In some institutional arbitration rules, there might be excessive procedural formalities. When you take up of the responsibility of procedures, moving from ad hoc to institution just for getting the administrative assistance, the good example of excessive procedural formalities. Here, the answer to the challenge is that we need to have stronger oversight of the mechanism. What generally is spoken about appointment of an arbitrator under Section 11 of the Arbitration Conciliation Act 1996. Anyway, Section 11 is within the scope of Section 11 is an evolutionary theory in arbitration if the parties or couldn't agree on a mutual need. Right? Ultimately, we are approaching the court, and the court is going to appoint the arbitrator in ad hoc, but in institution, the court of arbitration in that institution would designate or appoint the arbitrator. Pre-2019, the court can entrust by way of including subsection the concept of court-appointed arbitrator evolves after or pre-2019. Post 2019, many designated arbitrations or designated institutions shall be empowered. It is no doubt reduces the court burden, and the time normally taken in the courts is being totally compromised. It promotes efficiency and institutionalization when a Section 11 is invoked. What is a new trend here? In India, this trend is yet to be implemented, but across the globe in prominent arbitration institution, emergency arbitrator concept is there. In India also, the Indian Council of Arbitration rules facilitate, the MCA rules also facilitate. Overall, emergency arbitrator concept is being recognized by ICC, SIAC, SKAC, and MCIA. Here, the emergency arbitrator concept in institutional system is an innovation. It really ensures immediate protection of rights. On a personal note, when I was appointed as emergency arbitrator some 6 years back, that was my first appointment. After that, many such appointments came by an institution. Literally, I could pass an interim order as contemplated under Section 17 of the Indian Arbitration Conciliation Act within 7 working days. This might have been taken into consideration as the greatest opportunity for parties choosing to institutional arbitration, particularly if that particular institution in that particular jurisdiction having a provision for appointment of emergency arbitrator. No doubt, in India, we did have one interesting case, which is Amazon versus Future Retail, wherein the court, while dealing and challenge and enforcement of a foreign arbitral award as well as a domestic award, regarding SIAC administered arbitration seated in New Delhi. Here, the institution or institutional innovation is that it obviously strengthens and make effective institutional responsiveness. The institution is made responsible for each and every activity from the time of registering the case. It is normally called to be a case management. That case management is also constructive, but at this point, emergency arbitrator concept is recognized and makes the institution responsible. Okay. Having said that, getting back to the basics of arbitration, we are trying to say party autonomy, party control. When you're opting for institutional arbitration, whether it is going to be moving from party autonomy to institutional control, yes, my answer is yes. To a reasonable level, the party autonomy is taken away by the institution. The institution controls many aspects like procedures, removal of arbitrators, substitution of arbitrators in some country. In India, we don't have. Still, it is left to the arbitrators. But a general, a common points which we have to take into consideration when it comes to institutional administered arbitration, the challenge on the party autonomy, the control of the institutional control are just listed here. Institutional manage administrative aspect. The party's responsibility is to just to pay for it. That's all. Beyond payment, there is no role entrusted to the party. It is all entrusted to the institution. The administrative aspect is now entrusted to the institution. But still, the parties retain the choice of law, that is the substantive law. The seat, it is left to the parties concerned, as well as initially the choice of arbitrator also is in the hands of the party. If the parties are not making the appointment, then the institution takes up the role and appoint the arbitrator. But no doubt, the institutional control is considered to be a balanced control, ensuring the structure, that is the structure laid down by the rules, to some extent flexibility. The institutional control beyond the party autonomy makes or avoids procedural confusions and delay. The institution controls the procedural timeline in a crystal clear manner. There is no ambiguity in it. Technically, in institutions like ICC, there is a concept called terms of reference, TOR. The terms of reference is a document which is being prepared by the arbitral tribunal with the consent of the parties, authenticated by the institution. Once the pleadings have been exchanged, then the entire process has to be concluded within 6 or 7 months under the ICC rules, 8 or 9 months under the MCA rules. Likewise, every institution has its own control on the procedures and the timeline. It eventually, even though it is institutional control, it promotes efficient and credible proceedings. There's a very limited scope for compromising the efficiency in that particular process. Moving to the default role, that is appointing arbitrator by institution. How it has to be taken up. What are the pros and cons. The title here says that institution as appointing authority ensures impartiality. No doubt, they will find the impartial arbitrator to be appointed, which is not evident in ad hoc arbitration. How? Answer is, as earlier mentioned, most of the institutions maintain panel of pre-vetted arbitrators. That's very important. And the panel which is being maintained by the institution invites application for empanelment based on a list of criteria. If you take up Indian Council of Arbitration, it is mentioned that that arbitrator should not be less than the age factor, should not be less than 35 and should not be above 75. It keeps on changing, but at some point of time, the age factor was mentioned. Second, past experience of the arbitrators or the empanelment applicant for empanelment would be taken into consideration, whether it is the role of arbitrator or whether it's the role of a counsel before arbitrator, the role of an expert or consultant in arbitrations. All these would be taken up as another criteria for empanelment. It doesn't stop there. The arbitrator's experience or that person's experience in that domain. If you are a chartered accountant and if you are interested to be empaneled, the panel criteria, empanelment criteria would also address that 10 years or 15 years of experience in financial sectors. Based on that, only the application would be scrutinized and approved. A pre-vetted arbitrators panel would be available. With this panel, when it comes to appointment of an arbitrator, the institution would do an exercise. That exercise is called conflict check. There is a principle is that when a person from the panel is appointed, it doesn't mean that always he is independent or impartial. From that panel, an arbitrator's name, if it has been proposed, that arbitrator should have, or that institution would do a conflict check with that arbitrator. The conflict check is nothing but, which is based on an international soft law, which is called IBA guidelines on conflict of interest for international arbitrators. This IBA guideline is like a traffic signal which gives option for 3 lists. One red list, another green list, and the third one orange list. In a traffic signal, if it is red, we cannot move. If it is green, we can move. If it is orange, we have to be ready to move. We can move or we can stop, either way. The same principle applies for an arbitrator when it comes to impartiality. In India, fortunately, the Indian Arbitration Conciliation Act, in its 5th schedule, 6th schedule, and 7th schedule, have given a multiple categories of relationship which has to be declared under conflict check. India is one exception wherein the IBA guidelines has been taken up in the model law itself and it has been adopted as a mandatory provision. In India, in an ad hoc arbitration itself, when a person is likely to be appointed, he has to look into the 34 type of or categories of relationship. It might be professional, it can be personal, it can be social, it can be fiduciary, or it can be, or the relationship of any kind, whatever, but predominantly within the 34 categories of relationship, not only with the arbitrator, but with the arbitrator's close family members, with the disputing parties, the representative of the disputing parties, or if that outcome is going to affect a third person. All the things has to be seriously analyzed, and that conflict check makes that arbitrator perfect, at least in India and ad hoc also. But most of the jurisdiction, it is not that always ad hoc. Institutional arbitrations are used for international, and there a clear mandate is given for conflict check. The empaneled arbitrators, the names would be proposed after getting a conflict check, whether they are related with the parties or related to the parties representative or the dispute as such. It's very, very significant. That conflict check is conducted through the institution, the initial stage itself, before even the names are proposed. Third, the institution applied transparent selection process. It is nothing but the arbitrator's profile would be provided to the parties in detail so that the parties can also do a conflict check at any point whether there is a probability with analyzing those profile there is any conflict or whether they are capable. It is so transparent, democratic when the institutions appoint arbitrators, which we can't see in ad hoc. In ad hoc, if the parties couldn't agree when we are going to the court, particularly High Court for domestic and the Supreme Court for international, it is not actually transparent. It is all the discretion of the court to appoint the arbitrator. Here, in institution, when arbitrators are appointed, the prime principle applied is independence and neutrality. Here, it is clearly understood that the party's confidence and trust is built up. The ensuring quality of the institution when it comes to appointment of an arbitrator on the notion of impartiality and unbiased makes the parties confident and trustworthy when the institution arbitration is opted, particularly in the arbitrator selection. Moving to case management. Normally, in courts, there will be a registry. The registry will take care of entire case management, responsibility of maintaining the files, depository of the files, issuing certificate copies, allocating to the respective courts, getting back the files, dealing with all subsequent applications. In traditional courts, we do have the registry. But still, we are not interested. We are going for arbitration. In ad hoc arbitration, we don't have any registry. And there is no institution also. It is all managed by the arbitrator himself or herself. It is the sole responsibility of that particular arbitrator regarding case management, and there might be too much of negativity in seeing the arbitration delayed, increase in cost, sometimes too much of applications not decided during the arbitral process, making the outcome vulnerable to challenges in the courts. We have moved out of the courts, but still we need to have an effective third-party case management process. Institutions designate registrar. Every institution or most of the institutions do have registrars, deputy registrars, assistant registrars, case counsels. Similar to the court registry, these registrars have a constructive role in case management. They will coordinate procedural logistic. They will maintain all filings and do the communications. They monitor deadlines and hearing schedules. They ensure procedural discipline as well as fairness. They will be a bridge between the arbitral tribunal and the administrative function of the institution. In some institution or some institutional arbitration rules, under the case management, the draft arbitral award can also be scrutinized by the registrar or his team. It doesn't mean that the registrar is going to prepare the award, but still the registrar is going to identify any flaw in that award so that that registrar would ask that arbitral tribunal to make the necessary corrections, and then that award would be published. The effective case management makes that arbitration to be concluded within a reasonable time with a reasonable cost. There's going to be additional cost, but still reasonable cost, as well as the arbitrators are well guided by the registry on the arbitration rules of that particular institution. And if required, the registry also provide tribunal secretaries to lay down secretarial works entrusted to the tribunal secretaries. The role of an arbitrator or the arbitral tribunal would be confined only to analyzing and passing the award. All other activities would be managed by the registrar, that is the institution. The registrar representing the institution with his entire team would coordinate, maintain, monitor, and ensure, acting as a bridge. This case management is a very valuable point for the institution or for the parties to take up institutional arbitration rather than ad hoc arbitrations. This monitoring of timelines, what we could see in the earlier slide, which has been narrated here, makes the arbitration concluding within the time frame, what the institutional rule says or sometimes the country law says. This monitoring makes avoiding the procedural delay. It avoids the procedural delay wherein, if you can see, institutions impose fixed procedural calendars. Normally, institutions guides the arbitrators in preparing the terms of reference as well as issuing procedural order number 1, number 2, so that those procedural orders would be a guiding platform for that particular process. The institution impose fixed procedural calendars. There will be a regular progress of tracking and reports. The registrar enforces compliance with timelines. There will also be penal measures for unjustified delays, either on the part of the parties or the arbitral tribunal. There will be a penalty under the arbitration rules implemented by the registrar. And it also promotes timely award delivery. So much of efficiency you can see when the institution comes to monitoring the timelines. Monitoring the timelines is a very significant role of institutions. The institutions fix up the calendar, charges the parties or penalize the parties if there is a delay attributable to them or to even the arbitral tribunal. Here, this case management rates the institutions. There are many institutions already. We have seen ICC, SIAC, MCIA, ICA, HKIAC, many institutions, as well as IAAC of the CA Institute. If an institution, if he is going to effectively monitor the timeline, then that arbitration would be the most acceptable arbitration, whatever might be the outcome. As I earlier mentioned, scrutiny. Some institutions do have, in India also, few of the institutions do have the scrutiny of awards, but still it is criticized in many jurisdictions. But it is not that the core decision of the draft award would be reviewed. It is all on certain nuances and the procedures, it will be scrutinized. It is the institution which is going to review the draft award before it is being published. It is all about ensuring legal and procedural compliance. There shouldn't be any violation of the law that is against public policy, as well as there shouldn't be any procedural lapses. If something has been identified, then the institution would ask the arbitral tribunal to make necessary mutations or comply with the procedural directions which were already given by the same arbitrator or the tribunal, or which is being facilitated under the institutional arbitration rules. The review might be on very formal clerical errors, typographical errors, or computation errors. This is also identifying those errors. If you look on Section 33 of the Indian Arbitration Conciliation Act, it speaks about correction, interpretation, and issuance of additional award. These are all post-award if something to be corrected, typographical errors, grammatical errors, or some paragraphs has to be clarified, or if it is going to be some issues unanswered, by the arbitral tribunal, then those corrections has to be done by that arbitral tribunal. The arbitral tribunal in an ad hoc arbitration has to do on its own or by way of an application post-award. To avoid this delay, in most of the arbitration institutions, we do have provision for scrutiny, and that scrutiny identifies such errors, typo or computation or calculation error, then some clarifications if needed, that has to be identified. If certain issues are unanswered, whether allowed or disallowed, it has to be answered. If it is unanswered, all the three has to be listed out and it has to be notified to the arbitral tribunal so that the arbitral tribunal can make all those corrections or clarifications or even answer to the unanswered issues so that it will be a foolproof award to be published. Here, the institution, while scrutinizing, enhances the efficiency in enforcement as well as consistency. The best example, the first one, was ICC, International Chamber of Commerce. Under Article 34, we can see the scrutiny provisions. The scrutiny provisions is very clear. Moving to some institutions which are more than century old or more than 20 or 25 years old, which has a lot of significant value across the globe. Why they are so much important? What significant in their rules? Their rules mostly ensure fairness and predictability, but as ICC, we can see detailed oversight and scrutiny, that is, in my personal opinion, which are significant for ICC. In SAAC, the fast track and emergency features, and now the SAAC has also come down with streamlined procedures. Streamlined procedures, expedited procedures, and normal procedure with emergency features. Streamlined are nothing but disputes value of less than 1 million Singapore dollars go for an arbitration with one arbitrator, and that arbitration has to conclude within 3 months. Expedited procedure is for arbitration with sole arbitrator for the dispute amount of between 1 million Singapore dollars to 10 million Singapore dollars, and it is expected for the tribunal to complete the arbitration within 6 months. and the other arbitrations within a reasonable time with emergency arbitrators. So much of value in their rules. And this streamlined procedure was brought in 2025. And when you take on LCIA, London Court of International Arbitration, it all emphasizes on flexibility and transparency. And interestingly, for the arbitrators, the LCIA fee structure permits the arbitrators to charge the parties on hourly basis. 1 hour effective working on that arbitration, the arbitrators are entitled for their fees. These institutions are literally understood to have adopted the global best practices across jurisdiction. They have taken that particular rules, and those rules are so effective when it comes to implementing or using these institutions. Coming to the party autonomy, earlier we saw party control or the institutional control. Party autonomy, still the choice of seat, language, and the law is entrusted to the party. The core principle of arbitration law is not compromised. The parties are choosing the seat, that is a place. The parties are choosing the law, that is a substantive law. The parties are also choosing the language, that is the language of the arbitration proceedings. And it is also very clear that if the parties could agree mutually, fine, they have the right in choosing the arbitrators. They also have the right to shape their procedures. Still, it is that. But it is all balancing with the institutional arbitration rules. No doubt, party autonomy is maintained in institutional arbitration also. What are the limits where we do have a limitation on party autonomy? Sometimes it can be addressed as when institutional rules override the party wishes. There are some institutions having rules, and that institution would impose mandatory rules on certain things. Scrutiny of award is mandatory, even though in India we don't have a provisions for scrutiny of the arbitral award. The draft award won't be scrutinized. There can be possibility of enforcing timeline and ethical standards when it comes to certain institutional rules. When it comes to fees and cost structure, the party autonomy is very limited. There's a standard fees, it is regulated fees. Those fees and costs would obviously be collected from the parties, whether they prefer it or not. Here, the party autonomy is limited to better prevent the procedural abuse or unfairness and to maintain an order and discipline. In that way, there are certain rules. Those rules have to be followed, compromising the party autonomy, wherein to maintain order and discipline in this process, it is quite essential. What is the balance need we come across in institutional arbitration? Procedural flexibility versus standardization. Institutions blend flexibility with order. Sure, when you're going to ride on a road in India, we have to take the left. There are certain rules. We can't just be flexible on those rules. Institutions also gives certain rules which might be reasonably flexible, but it is for the betterment of the parties so that some balance is there to have a standardization. Parties adopt procedures to the case needs, depending upon the value of the dispute, the streamlined, expedited, and the normal arbitrations. Across many institutions can see that it is flexible, but they are making a standardization so that parties have the choice to adopt the procedure based on the particular rules. Standardized steps ensure predictability. Very, very important. Whether the time it's predictable, whether the cost is predictable, whether the procedure is predictable, whether the neutrality, it is also predictable when it is standardized. To reasonable level, it promotes fairness and efficiency. Interestingly, in complex cases, we can reduce uncertainty. Example, complex case. If there are more than two parties, multi-party contracts, there will be multi-party contracts that also comes to arbitration. It can even go to institutional arbitration. Here, the institutions are very particular on multi-party, having clear guidelines, rules within that arbitration set of rules, which reduces uncertainty. There will be too much of complexity in multi-party arbitrations in ad hoc manner, but in institutional manner, there will be a flexibility and a standard so that the uncertainty would be removed. How to go to institutional arbitration? To opt for institutional arbitration, we do have a thumb rule: choose and incorporate the model arbitration clauses. When you want ICC, when you want SIAC, when you want LCA, when you want MCIA, when you want IAAC of Chartered Accountants Institute, when you want Indian Council of Arbitration, no worries. At the time of entering into the contract, while including an arbitration clause or a dispute resolution clause, simply adopt the model arbitration clauses recommended by those institutions. Those are pre-drafted clauses which are ensuring the validity. If you have the model clause of those institutions, at the time of invoking the arbitration, those institutions would straight away accept and register the cases, and the cases would start instantly at the time when the request is made to that institution. If you are trying to adventure with those clauses and change those model clauses, there might be some difficulty for those institutions to accept the case or register the case. It is better to adopt the model clauses because every institution provides model clauses which are available in public domain or in their rules book. If we adopt the model clause, it will avoid ambiguity in the arbitration agreement, and it also ensure enforceability and uniformity. It's very important while choosing institution. Ad hoc, it is flexible. You can draft your own in any manner an ad hoc arbitration clause subject to making it to a valid arbitration clause. But when it comes to institutional arbitrations, when you want institutions to be taken up, simply adopt the model arbitration clause of the respective institution which you want to choose at the time of entering the contract. Even in the later stage, when a dispute comes and when you are opting for it, with the consent of the other parties, you can very well adopt the model clauses. Coming to cost, how fees are calculated in institution and why we also say that it is reasonable. Even though there is an administrative fee additionally, still there is a predictability. Parties can predetermine what will be the cost, which is not possible in ad hoc until and unless the fourth schedule was included and made it to be a mandatory fee structure. Transparent and predictable fee systems is there. When you look on these institutions, assuming that we have a dispute value of 10 crore Indian rupee, and when we go to the Indian Council of Arbitration cost calculator, put that amount with one arbitrator, three arbitrator, it gives a clear chart of what would be the cost of the arbitrator, the fee of the arbitrators, the institutional fee, all would be given a chart, minimum, maximum, and an average. It is predictable. The fees mostly would be linked to claim value or sometimes time spent. Like LCA, it's all time spent, but all other institutions are claim based on the claim value. It includes the registration fees, the arbitrator's fees, the administrative costs. Everything would be included, and the breakup would be crystal clearly mentioned. It also avoids unexpected financial burdens. Here, in most of the international arbitrations, if the parties are not keen or not in a position to provide fund for the arbitration, then they can very well approach third-party funding agency to conduct this arbitration. And the third-party funding institution would be in a clear understanding of what would be the charges, what expenses would be incurred. They will lend money for conducting the arbitration if it is an institutional arbitration in a crystal clear manner on the fixed amount. In ad hoc also they do provide, but it won't be so clear what would be the predictable fee. In institutional, it is clear, it might be higher, but still it is predictable and we can implement. Most interestingly, it encourages accountability. When it comes to arbitration, the apportionment of cost, the final stage, which party has to bear, whether the losing party or is going to be sharing, a proper accounting can be done when we opt for an institutional arbitration, so that the memo of cost incurred by the respective parties would be provided by the institution well in advance to the arbitral tribunal, even before preparing the draft award. Okay, what is the institutional fees, the administrative fee, which has a breakup, registration, administration of the arbitrator's fees? Registration fee, no doubt, it's a one-time filing charge, but it's non-refundable. Administrative fee is about covering the case handling, that is the case management. These are some terms used in many institutions. In India, it is sometimes one, but across the jurisdictions, we do have registration fee and administrative fee. First, registration fee, that is one time. Administrative fee covering the case management or handling. Then the arbitrator's fee based on the claim value or the time spent. Then the hearing and service charges also is applicable when that particular jurisdiction, the institution is going on that perspective. But overall, we can see it promotes clarity and transparency. And this cost breakdown, if you look on in most of the institution, it is all about the administrative fee to be higher or equivalent to sometimes the registration fee. Schedule of fees, comparison. Some example, it is with a disclaimer. ICC is on ad valorem. The fee module is structured, is quite expensive, but high value arbitrations are being taken to ICC. SAAC, reasonably cost sliding scale based on dispute amount. MCAA, Indian model, the slab-based Indian cost model based on similar to fourth schedule, reasonable. It all reflects jurisdictional and economic factors. The Western Europe or the seat of arbitration or the institution coming from the developed economies, the OECD countries are quite expensive, but still people do go to those institutions. Cost doesn't matter for them. Countries like developing to reasonable levels, like the Singapore one, having a premier services also provide, but with a reasonable cost. Jurisdictions like India, the developing one, or the least developed or underdeveloped jurisdiction has a lesser cost proportions depending upon their services. It all differs, but the choice all depends upon how the arbitration rules and their cost is being highlighted. The only thing is that it is all the party's choice. The cost factor and advance can be seen in the public domain, making or allowing parties choice based on the affordability. In India, 31A, the cost regime, which was included in 2015, allocation of cost. The tribunal is empowered to allocate cost. It might include the legal, expert, and administrative fee. It encourages cost efficiency and discipline. It is also reasonably aligning with the international practice. Transparency in cost, prefixed schedules avoid hidden charges, promoting confidence among parties, enhancing institutional accountability, enable budgeting and planning, improves perception of fairness. There is an arbitration clause, the advantage of prefixed fee schedule of institution. The transparency is there. As I earlier mentioned, that traffic signal red, orange, and green. Unfortunately, the picture is showing something different. It has to be changed as orange and green. The conflict of interest in institutional arbitration also is based on IBA guidelines. Red, serious conflict and disqualification, that is ineligibility of an arbitrator. Orange, potentiality, expected disclosure is there. Green, there is no conflict. These are all just a repetition of ensuring transparency and neutrality. The independence of an arbitrator, institutions ensure impartial selection, mandatory conflict disclosure obligation, similar to Section 12 to 13 of the Indian Arbitration Concession Act. Here, it also doesn't stop with the initial stage. The continuous duty to maintain independence also is maintained by the institution, so that the process, the arbitral process, and the trust building on the process is evident. Okay, this might be a negativity initially in my understanding, confidentiality concern. We are saying arbitration, particularly when you're looking section 42 capital A of the Arbitration Concession Act, the 2019 amendment. It says the arbitration proceedings should be kept confidential until and unless it goes to the court for enforcement or challenge. Strict confidentiality is there, but here there is a third person, institution, and the institution secretariat is coming to know about entire process. But still, that institution is interested by the parties in that way. Even though it is transparent, that institution also has to make that process confidential. Strict confidentiality of the proceedings and documents has to be maintained by the institution. It is their approach or their rules might facilitate. If it is online, the secure online system and access control should be placed by that institution. And when it comes to case, the limited public disclosure during enforcement also can be maintained by institution. Most of the institutional rules do have confidentiality provisions, and we had to choose an institution which clearly mentions the confidentiality subject to a reasonable transparency with that institution. Most of the time, confidentiality is all about protecting sensitive business information so that it shouldn't make up a defamation situation for the parties in future contracts or evolving a continuous business relationship with any other parties or even the same party. We do have some practical things to consider. There might be some party non-cooperating or misconduct. The institution also might be in a KV situation, how to manage, but still some institutions are managing. Arbitrator scheduling conflicts. Sometimes the arbitrator's availability also matters. The complex multi-party disputes also is a challenge. Heavy institutional caseloads. Some institution might be having heavy caseloads like Chinese arbitration institutions, CTAB. China International Economic and Trade Arbitration Commissions, that particular CTAC has more than thousands of cases handled every year. That might be a challenging situation. Need for stricter enforcement mechanisms. Not all institutional rules are rigid on it. It is flexible because to have the parties autonomy of control. But if there are stricter enforcement mechanism, or if there is going to be delay attributable to the parties or arbitrators, and the rules permit some penal provisions, then there will be a control on this challenge. Regarding enforceability, no doubt, institutions stationed in New York Convention countries enjoy higher credibility. The scrutiny also ensures procedural soundness. Most of the jurisdictions, more than 170 countries, have adopted New York Convention. That way, institutions from these jurisdictions also flourishing and clear on the mandate, whether it is institutional arbitration or ad hoc arbitration. Anyway, the enforcement is going to happen in the national courts, but without hindrance. Key advantage of institutional arbitrations, looking upon its efficiency and predictability, professional administration and expertise, predictable procedures and rules, qualified arbitrators panel, reduced judicial intervention, and faster enforceable outcome. It might be a repetition, but these are the key advantages. Professional administration and expertise, predictable procedures and rules, qualified arbitrator panels, reduced judicial intervention, fast and enforceable outcome. It also goes to the panel of experienced arbitrators. As I earlier mentioned, institutions maintain expert panels in various domains, provide technical and legal guidance if required, ensure consistency in proceedings, sharing global best practices, and enhancing arbitration quality. These are some emergency reliefs, that is, emergency arbitrators relief based on the institutional framework. Global acceptance, that is the New York Convention enforcement in detail. 170 plus countries have adopted this. A comparative advantages, India versus international. MCA, it promotes the cost-effective reasonably. ICC and SASC global benchmark. But interestingly, India's legal reform is going to attract global users to come for institutional arbitration in India, and there is going to be a competitive edge through affordability. Cost and the quality is going to be the future of institutional arbitration, particularly Indian institutions providing arbitration services. ICC, based in Paris, LCIA, based in London, 1892, very old institution. Singapore, 1991 institution, but now one of the world leaders providing institutional arbitration services. Hong Kong, predominantly dealing with mainland China. Earlier, it was an independent body in Hong Kong. Now, after the Hong Kong Special Administrative Region, it is also dealing so effectively the mainland China cases. China being the major trading partner of any country in this world, every disputes mostly end up in having one party from China or the China Special Administrative Region, wherein they prefer to have Hong Kong to be, and particularly Hong Kong International Arbitration Center provide that particular service as institutional arbitration facilitator. And interestingly, it is bilingual, English and Chinese, and it is also strategically positioned for China-related cases. Mumbai Center in India is also a good example. 9 years have gone, and they are doing reasonably administered arbitration for mid-size value arbitrations. The fast track and expedited, which I earlier mentioned, 6 months, 3 months, the streamline, are all facilitated by institutions also. Technology also is facilitated by institution, and online hearings, e-filing, and online dispute resolution services also is being given by institutions. The case management by registrar, the scrutiny and quality control, all are quite significant provisions. And as a takeaway, institutional arbitrations ensures efficiency and fairness. In India, the 2019 amendment is a paradigm shift or a greater reforms to promote institutional arbitration in India. In India, instead of choice-based marriage, now arranged marriage is being facilitated in arbitration. Go for institutional arbitration. That is the mantra of the 2019 amendment of the Arbitration Conciliation Act 1996. Technology also enhances accessibility and transparency. The global standards improving trust and adoption. Anyway, the future there is going to be the parties, arbitrators, the institution, and the technology, that is a fourth eye, is going to take part in the arbitration process along with institutions. Friends, thank you for patiently hearing the short presentation about institutional arbitration, the nuances or the basic understanding of ad hoc, and the difference between ad hoc and institution, the advantages of institutional arbitrations, and what would be the future of institutional arbitration in our country.
Thank you so much, sir, for sharing such valuable information with us. Sir, there are two queries posted by the members. The first one is, can banks settle their borrowers by arbitration? Is there any statistics for such settlement?
When it comes to nationalized banks in India, they do have a policy structured by Indian Banks Association, and for the dispute above 10 lakhs, and it all depends upon the pecuniary value, the debt recovery tribunals have been approached by the banks. But when it comes to scheduled banks and other private banks, they are doing arbitration by incorporating arbitration agreements in the loan agreement itself. But the nationalist bank have to wait for the Indian Banks Association to take a policy decision to switch over to banks, to arbitrations.
Okay, sir. And the second query is, why multinational companies prefer institutional arbitration over litigation or ad hoc arbitration when resolving cross-border disputes?
When it comes to cross-border disputes, MNCs, obviously, they might have their incorporation done in some other country. They won't be very keen. Even if it's an Indian MNC, they might do projects in multiple jurisdictions or multiple countries. And when they are opting for court litigation, it will be quite difficult to go to which court. It all depends upon the laws or the legal systems of each and every country courts. And sometimes the country court might be hostile to the other party. This is one. Why they are not opting for ad hoc arbitration? Because they need predictability on the cost. Most of the MNCs have to have a budgeting well in advance when they choose to go for dispute resolution. And when they are going for institutional arbitration, there'll be a reasonable predicament for or a determination for the cost. They can budget it for it. If it is ad hoc, it's quite hard to budget. And there is another problem also. The ad hoc system facilitates only applicability of the national arbitration law of the seat of the arbitration. And MNCs might have multiple in a single contract. The execution of the contract might happen in multiple countries. And when we wanted ad hoc, it is not so easy if we had to keep on changing the seat. If it is happening in India, the seat, Indian Arbitration Conciliation Act would apply. If they're going to do it in Bangladesh, the Bangladesh Arbitration Act would apply. If it is going to happen in a country like Australia, the Australian arbitration law would apply for the procedure. There will be multiple complexity. If we opt for an institution arbitration, we can take an example of Singapore International Arbitration Center. SIAC can do the arbitration in India. SIAC can do an arbitration in Bangladesh. SIAC can do an arbitration in Australia. And the simple understanding, SIAC arbitration rules alone would be applicable for the procedure.
Thank you so much, sir, for clearing the doubts. Now, on behalf of this committee, I would like to thank our eminent speaker, Invavijian sir and Piyush sir, for gracing the webinar with their presence. And I would also like to thank all the participants for being such an amazing audience. Thank you so much, sir.
Thank you. Thank you. And best wishes for the CA Institute and CA Institute Arbitration Center to flourish and provide the services for all sectors. Thank you.
Thank you. Thank you, sir.